Mr. Speaker, I want to just come back to this point and this one that we've been debating about whether or not this right to be present at one's trial, where one is the accused, is a fundamental, absolute right. And I come back to it because, again, I say to the House, it's not. It's not an absolute, fundamental right. I accept that everyone in this room, and indeed I think in New Zealand, would accept that the norm by a vast way, in nearly all cases, perhaps all cases practically speaking, an accused will be at his or her trial. But I say to this House, and I say to Kennedy Graham, what I said last night, and that's this, that the common law did evolve and has evolved scenarios in a strain of cases where they have taken that right from accused. And I've made it, and I've said to my friend that to Mr. Graham that this has come from the House of Lords. Actually, if you want to look around the common law world for a court that more jealously guards against and fights for the rights of humanity, I think you'd be hard-pressed to go past the House of Lords, now called the Supreme Court. And in 2002, they made it clear that there may be such cases. And I hear from David Parker, well, only in the case of misconduct. And that's right, and I'll come back to that. But the scenario that they've gone with, that High Court judges in this country have also gone with in recent years, case that I found quickly last night, Queen and McFall. I'm aware of another case involving Justice Heath in the Hamilton Court, High Court as well, was where accused that had absconded, didn't turn up for trial, and the judge in rare cases has said the trial will proceed anyway. That's right, because of their misconduct. But my point to members of this House, actually I can envisage situations where we would have AVL for the same reasons. I accept to be extreme cases, very extreme cases. I said, and Kennedy Graham said last night he didn't accept this, but I said there may well be cases, not often at all, of accused coming to court, not being insane to a criminal standard, but having, let's put this euphemistically, serious issues where they are wanting to harm themselves, perhaps harm others. Perhaps they cannot be shut up at any time during their trial. They will not be, for whatever reason. They're hurling profanities at the judges. That actually happens more often than we like to think in courts in this country. Now, they can be removed, but what is better actually, doing the trial without them, which actually the common law could foresee, or having a trial where they do it by AVL? Well, I say to the House, actually, in that rare extreme case, and I accept it would be rare and extreme, that would be a scenario where AVL would be justified. I think of that, look, literally without having given the particular point of the various manifestations and ways and wherefores where you might use AVL for an accused. But that is one situation where you might do it. So I say again to this House, look, the common law has envisaged situations where an accused does not have an absolute right to be at trial. I'm saying actually through this bill we are leaving the door open, but let's be very clear, we're not leaving it very wide open at all. We have many safeguards in this bill. As I said last night, there's 3 clauses a judge will have to work his or her way through, and clause 6, if I can put it this way, is exceptionally strict. When we work through those, 6A, I think it would be a very brave judge who would find his or her way through that and rule out AVL, or rule in AVL, I should say, for an accused, and not envisage an appeal up the chain of courts because of that. So it may never happen. but it may also, and we're doing the right thing.